Good afternoon. My name is Janet O'Neill. I'm a California-based certified paralegal, family law mediator, and family law coach. This video is meant to help individuals understand the complexity of marital settlement agreements and why they tend to fail. Marital settlement agreements break down far more often than people are told before they sign them. This is not because people are dishonest, not because people are unreasonable, although sometimes they are, but because many agreements are built on assumptions about cooperation, assumptions about enforcement and control that simply do not exist in real life. Courts do not enforce agreements for you. Once a settlement becomes a judgment, a court does not monitor compliance. It does not step in automatically when problems arise. Enforcement of agreements only happens if one party takes action. This is through motions, hearings, and by far more additional expenses. That reality is rarely explained clearly before settlement. One of the most common and costly misconceptions in family law settlements is the belief that giving up assets will buy peace. Unfortunately, people give up property, retirement funds, or financial leverage thinking it will reduce conflict and allow them to have more time with their children. What they are not told is that custody and visitation orders are among the most difficult orders to enforce. Unlike money, parenting time cannot be collected, garnished, or seized. In California, if a child refuses to go to the other parent's home, the receiving parent cannot physically force that child to go, and the court cannot practically compel a child to participate in visitation against their will. Courts do not order parents to drag children into cars. They do not send law enforcement to physically enforce routine parenting exchanges. As children get older, the court's ability to enforce visitation becomes even more limited. This means that even when a parent gives up assets, believing they are securing peace, cooperation, or stability in parenting time, there is no guarantee that peace will last or that visitation will be honored. When conflict resumes, the assets are already gone, and the parenting time may still be disputed. Another major reason settlements break down is vague or incomplete language. All too often, agreements rely on terms like reasonable, mutual agreement, or flexible scheduling. Courts do not enforce intentions. They enforce written orders. If language is unclear, the court will not fix it later simply because enforcement becomes difficult. Judicial discretion adds another layer of unpredictability. Even carefully negotiated agreements are subject to interpretation. Two parties may believe that they've agreed to the same thing, only to discover later that the court views the language completely different. Settlements also fail because people settle too quickly. Without consideration, they are emotionally exhausted, financially strained, focused on ending conflict instead of understanding long-term consequences. And finally, many settlements assume that people will change, that conflict will decrease, or that cooperation will improve. Legal agreements do not change behavior. They only set boundaries. If an agreement is built on hope instead of structure and enforceability, it will not hold up under pressure. These videos are informational only, and they are intended to be thought-provoking to help people think about issues they are rarely warned about before settlement. Our goal is empowerment, so people understand what settlements can and cannot do, what enforcement actually looks like on an ongoing basis, and why giving up assets to buy peace often leaves families with neither peace nor protection. In the next video, I'll explain how mediation and coaching can help people make informed decisions before they give up leverage that they cannot get back.